Good evening, everyone. Sorry, our moderator will soon be joining us shortly. Sorry, I think he just had a bit of network issue. God's love, hope you can hear us better now. God's love, can you hear us?
Yes, it's much better now from my end.
All right. Thank you very much. Okay, I will just quickly run the introduction while we wait for our moderator to get back with us. So, good evening, everyone. Welcome to week three. Right, this is the third session that we are having for our intellectual property course on the JIIPCC mentorship and internship program. Right, you're officially welcome to the third week. Our topic for today is registration, infringements, and IP registration, infringements, and enforcement. So you're all welcome to class today. I can see one of our mentors already on call. Thank you so much, Miss Oyekachi, for joining us. You're welcome. Right, I want to especially welcome all our mentees and also our moderator, whom seems to be having a little network issue. My name is Dennis Williams, and I'll just be stepping in briefly for our moderator while we wait for him to get back on. So I think running through the announcements for today. Firstly, um, so we've started registration for the next quarter of mentorship. So I would like to encourage everyone who so far has been a beneficiary of this particular program. I'm sure in the last 2 weeks you've learned quite a lot of things on IP. You've gotten professional insights and just general overviews on the IP space, on what IP is, what the IP industry looks like, right? And I'm sure you don't want it to just stop or end with you. Just like most of our mentors always come here and reshare their knowledge, we also like our mentees to also share with others our flyers and our links so that we can have more people benefit from our program. So registration for the next quarter of mentorship is already ongoing. So if you have friends and family who may be interested, or even colleagues who may be interested in our program, you can do well to share our flyers with them. You can reach out to me and I'll share the registration link with you so that you can send to them and they can register. I will do well to reach out to them via mail. So thank you for that. Introducing our mentors for today. Our first mentor for today is Miss Amosa Shukurat Modupeola. So Miss Amusa has been with us here, both first week, second week, right? And I just want to specially thank her for always making out time to make sure that she comes and share her own, like from her own perspective, her own point of view, her own point of view on what the IP space is like. So we'll just be running through. I'll just be running through her profile very quickly. Miss Shukurat is a seasoned intellectual property consultant, analyst, and educator with public sector experience. She holds a master's degree in intellectual property from the prestigious Africa University, Zimbabwe, in collaboration with WIPO and the Japan government. Shukurat is an alumni of the World Intellectual Property Organization, a member of the WIPO International Network for IP Education, as well as a training facilitator at the NEST Innovation Hub. She is a member of the planning committee for the WIPO National IPSC Competition 2023 and resource person at the National Intellectual Property Conference. Shukrat is an accredited agent at the Intellectual Property Office in Nigeria and the pioneer of the Intangible Nuggets, an intellectual and educational platform which is responsible for fostering, amongst other things, intellectual property advocacy, awareness, and education. We want to say a special thank you to Ms. Amosa for always choosing to be with us and always choosing to come mentor. Right. Our next mentor here, who is already on call with us, is Miss Onyekachi Eru Obu Aneide. I'm so sorry, Ma, if I did not pronounce your name very well. Please forgive my manners. Ms. Onyekachi, a lawyer and former TV presenter, joined the Nigeria Civil Service in 2014 and was posted to the Commercial Law Department, Federal Ministry of Industry, trade, and investments. The office mandated to protect industry properties in Nigeria. Onyekachi's dedication to work and intellectual property is evident in her various roles. She served as the secretary to the board of survey desk officer of the Federal Civil Service Strategy and Implementation Plan 2001 to 2025. And as the patent examiner, she is recognized as a federal civil service innovator and future leader. She has extensive knowledge in intellectual property system across various countries, having completed exchange programs with other IP offices, a master's program from Africa University sponsored by WIPO, a diploma in IP paralegal from Lokisco, and membership in WIPO International Network for IP Education. Driven by a passion for IP, she actively creates information, content, and engage in intellectual property discussion whenever the opportunity arises. Her legal background, civil service experience, and dedication to IP make her a valuable asset. She has a very interesting profile, and I'm sure we look forward to hearing from her. You're welcome, Miss Oyekachi. Thank you for joining us. Our third mentor for today, is Mr. Max Ikombe. Max Ikombe is the founder slash principal of Ever Law Associates. He works extensively in the field of arbitration, ICT technology law, and intellectual property. Max is a facilitator on the annual Information Technology and the Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property law courses at the World Intellectual Property Organization Academy, and he is an accredited agent of the Nigerian Trademark and Patents Register. He has conducted IP registrations businesses there since 2010. You're welcome, Mr. Max. Thank you for sparing your time. And in the words of our moderator, who will still be having with us, the Mazi of IP, you're welcome, sir. Um, our fourth mentor for today is Mr. Christian Anukwe. Um, Mr. Christian is the managing partner at Strems and Beyond Partners. Christian heads the IP prosecution and commercial law service department of the firm. Christian is a recognized 2022 world leader in the World Intellectual Property Review under the trademark and patent category. He specializes in IP portfolio management, brand protection, and anti-counterfeiting actions and business advisory. Christian is a member of several national and international groups and associations, including the Nigerian Bar Association, Intellectual Property Law Association of Nigeria, International Trademark Association Committee, IP Committee, and Anti-Counterfeiting Collaboration, amongst others. Christian was in September 2021 appointed a member of the Geographical Indication Committee of the International Trademark Association. He was in October 2022 named a top IP lawyer by the IPR Gorilla magazine India and was awarded the Esquire Nigerian Rising Star Award 40 professionals under 40 years category. Christian currently coordinates the practice direction drafting committee of the Nigerian Trademark Registry. Christian is also a published author with several articles in local and international journals in his name. Christian is a graduate of law school from the University of Nigeria, the Nigerian Law School, Abuja, the University of Illinois, um, Urbana Campaign, and Urbana Campaign. Christian started his career in RP law practice at the law firm of Aliko and Oyebode, and has also worked as a research assistant to judicial officers. Thank you, Mr. Christian, for joining us. I see you're already on call here with us. You are very much welcome, sir. Um, okay, I think that's the last of our mentors today. So over to you, God's love. Please, you can carry on with the session. Goslov, are you with us? Okay. It seems Goslov is still having network issues. So while we wait for him to join in, right, we'll just be having a brief introduction from our mentors. Last week we kind of overshot our time, so we would just like to kindly plead with our mentors to for a brief introductory sessions um, while we wait for other mentors to also speak. So I think we'll start with Miss Oyekachi. Ma, please, you have, I think, 15 minutes for your introduction into today's topic. You're welcome, Ma.
Hello, everyone. Good evening. How many minutes do I have?
Yes, there about 15 minutes, Ma. 15 minutes.
15 minutes for my intro. You want me to
Yes,
start
ma'am.
lecturing or just my introduction? For 15 minutes? Do I have up to 15 for
Yes, ma'am.
introduction?
You have up to 15 minutes.
All right. Thank you. So, do you mind if I share my slide?
Please, Ma, go ahead.
All right, then. I got the wrong one. Okay. So, good evening, everyone. My name is Jiipcc, area Banide. I'm happy to be here today. So, let's begin. So, based on the topic I received, registration, infringement, and enforcement of intellectual property. Can someone confirm I'm audible?
Yes, you're audible, ma.
All right then, thank you. So for start, what is intellectual property? So my only tool of saying intellectual property is a tool for protecting creations of the mind. And then depending on what you come up with, it could be registrable as a copyright, industrial design, trademark, and then it could also be a patent. So it depends on the outcome of what your mind has created. So first, I want to quickly look at an industrial property, because this is because intellectual property is broadly divided into two. And industrial property is housed under Commercial Law Department, Federal Ministry of Industry, Trade and Investment. On the other part is the copyright and related rights under Nigerian Copyright Commission. So briefly, industrial property, what do we have under industrial property? We have the trademarks, industrial designs, and then you have patents. So what are trademarks? They can be names, they can be logo, they can be letters, they can be numbers used to identify goods. And before you can register a trademark, you understand that there are various rules to register a trademark. For instance, you must be able to distinguish. It must not be identical to someone else's mark. It must not be confusingly similar. In fact, it must be an identifier. And I always like to liken trademark to a person's name. And I always use this example. If you're in a market square and it's a location, say in the east, and we know the surname of Okafor is a very popular one. And then when you call out Okafor in the market, you're sure so many people will turn back to want to know who's calling out to them. So this is exactly what happens in the market. You go to the market and you say you want to buy, say, rice. Rice is a very common commodity. The name is generic. You can't just say, I want to buy rice. Especially if you're buying the bag, you must be able to say, okay, I want to buy rice by so company or by so name. So which is why you must narrow the name of the product beyond the generic name that is used to identify the product in its class. So still using that example, Okafor, that I can say, I'm asking after Okonkwo, then I can say Ikenna Okafor. Even if there is another Okonkwo Okafo, it may not be Ipenna Okonkwo Okafo. So it helps to narrow it down to particular products. So this is what happens to your goods in the market. So you can't just come to register a trademark and they give a generic name. Somebody will say, cool water pack. What is cool? Everybody has a right to feel cool about something, you know. So such names can be given. That's that on trademark because of time. We move to industrial designs. This has to do with the aesthetics of a product, the beautification of a product. What makes the product attractive in the market? So if I go to the market, beyond knowing the name of the product I want to buy, in fact, I always say before the name, what attracts people to a product, especially when they are just new to the market, or when you just come from your home, you don't have a particular brand in mind, is usually the package. How the product is packaged attracts you. This falls under industrial design. And then go to patent. Patent will normally be the mechanics, the engineering beyond, you know, that makes a product to work. For instance, all these lamps you see here, they're not just the aesthetics. The outer part of it is what makes it beautiful, which falls under industrial designs. But what makes it a light up is what falls under patent. So this is the functionality. Patent deals with functionality, while industrial designs deals with the aesthetics. That's the outside, which can be color, the shape, and what have you for industrial design. And they will have copyrights and related rights. So simply put, what are copyrights? It can be artistic creation, literary works. Examples are books, paintings, and what have you. And then because of our age today, it's more of a digital age, digital economy. Everybody has gone online for one reason or the other. So when situations are presented online, such as a digital marketing, digital buying, they always fall under copyright as well. And then related to that is also domain name registration for those living online. They also want to consider taking up domain name registration, not just to go online to start a store. So it goes beyond just the book, the music, the paintings. Now it accommodates things like online shops, online stores, where you can do your buying and selling as well. And then you also have the related rights, like performance rights and what have you. All right, the rights of an IP holder, there's so many of them. So I'll try to break them down into this. So if I hold an IP, I have a right to use it all by myself. I have a right to be selfish about it. I also have a right to share with someone else, either for money's worth or otherwise. So if I hold an IP, say in a particular product, I can choose to, someone is working on my slide. Do we have control? Hello?
Yeah,
Hello,
yes,
ma'am.
ma'am, we
Yes,
can hear you.
we can hear you.
Yes, I said somebody is tampering with my slide. Do you have control over it? There are markings on my slide, which means that somebody perhaps is not supposed to be in the meeting. But if you're not bothered by that, I could go on. So part of the right of an IP holder is the right to exploit his rights. So I can choose to use it personally, exploiting it by myself as an individual, such as opening a store and then putting in my goods into my store, and then I sell directly to people. Maybe I give out right of distributorship to people, or I franchise the goods. I can also decide to exploit by act of, say, assignment or license, like you use those instruments. I can also export, I can also import, depending on my choice of how I want to exploit my rights. Beyond this, as an IP holder, I also have the right, statutory, to say I want to surrender my rights. I don't want this right, or though I created this right, I want the public to use it without paying me. But just know that before you can use an IP holder's right, you need to seek consent. And that consent usually falls under maybe a license or an assignment, depending on what works for the parties, because parties are bound by their agreement. All right, so what then is an infringement? I'll be using examples to explain what an infringement is. Intellectual property infringement can take any form can be on any kind of platform, say on the digital space. It can also be, say, in the regular market, where you go to the market, you find somebody is selling your goods or has imitated your goods and is selling in the same market where you're operating. So copyright, for instance, copying a similar design without permission for industrial design. Say maybe I make a bag or I make a t-shirt and I put maybe a design on it. And then somebody copies that design and transfers it into another kind of product. Say maybe it could be a bag, but it's the same design that I've carved out for my own design, though it's a bag. There is already an infringement. Also, using like copyrighted work without permission, such as all the songs you see in the digital space. And in these days, it's so difficult to track down who is infringing, who is not infringing, who is the original owner. Because everybody is copying and pasting, everybody's transferring, everybody's sharing on social media. You and I are equally guilty of this. Another one is selling counterfeit goods in the market, imitating a protected trademark. Say fake handbags, it looks so real, you can't even tell them apart. Fake software, just think about it. We see all this, they're very common in our open markets, and some of us are equally guilty. Because though we know they are fake, we feel they are cheaper, and then it makes us feel more. So we patronize them. Making or using or selling a patented invention. It's not my invention, I stumbled on it. So I decided to maybe make exactly the same thing through reverse engineering. And then I go out there to also sell it or to work the patents. Maybe it's a patent that has to do with a process or method of doing something. And then I work it, get the same end product, and I rush the market to sell without waiting for this rights to expire. Also note that for me to use all these rights, apart from getting authorization to make use of such rights, I also need to note that there are sometimes me as a right holder may be the cause of my own problem if I don't protect my rights. So before we go further beyond this infringement, what then do I do if I know that people can copy my work without permission? If I know people can sell imitated goods without my permission, what then should I do? The major thing that must come to our mind at this point is to register your product, to register your services, whatever it is you do. Whether it is a song, whether it is a book, whether it's an artwork, you seek copyright protection. Although it is said that copyright is automatic, you don't need to register for your right to start to become operational. But it's important to deposit a copy with the NCC as a way of saying, I have evidence that I'm the first to create this work. So nobody can claim tomorrow that it's their work. Also for trademark, it's equally important to register your trademark so that when somebody copies your work, it gives you a ground to sue the person to say, oh, this person has copied my work, he has imitated my product and he's selling the market, so you can go after the person. Beyond this, we can also talk about opposition. Even before you say you want to go to court to sue the person, you can also use opposition. I think I have a slide that talks about all that. So I was trying to say before that sometimes you may be the cause of your own problem. For instance, if it is a patent, we all know that patents will expire on the 20th year anniversary. And every year, within those 20 years, they're expected to pay what is called an annuity or renewal to service that patent. And so if you decide not to service your patent, what happens is it starts to become, stops being operational. People can take advantage of that patent. Although maybe not so much in Nigeria because we don't have a strong IP system. By ideally, when you are not working your patent, it's evidence someone needs to say, okay, looks like this person is tired of this patent. So when they check the status of your work, they can decide to use or imitate whatever it is you have created. Other times you can choose to abandon because you're tired, because its cost implication is too much more than the benefits you've been getting from the mark. You can decide to also abandon the mark. Sometimes you can decide to vary it, like when it comes to industrial design, even before the lapse of the 5 years, because it will last for 15 years, 5 years, 3 terms. And then maybe you're tired of that particular design, decide to vary your design, and then stop using the first part of it, and you're tired of using that particular one for whatever reason. Although the right will still be protected, because you have varied the rights, somebody might think, oh, no longer use this right. So that means it's free for me to use. So this may be some reasons why, although your right is protected, people are tempted to come to your rights, to make use of your rights, because they feel it's abandoned, and so it automatically falls into the public domain, even without expiration. All right. So someone asked a question. I got a question. So I don't know if you, the moderator that's supposed to ask this. That's in practice, what's the more frequently used and more effective remedy to seek against IP infringement? For me,
Okay. No, we'll come
okay.
to questions at the time for
All
questioning.
right, that's
Thank you.
fine. So I'll rest my case here, knowing that we have other experts here. Thank you.
Thank you so much. Thank you. It's really a pleasure seeing you again. Thank you for such a great presentation opening today's discussion. Thank you. Okay, ladies and gentlemen, good evening. I'm sorry, we're having some issues with my network. My name is Goslov Kamaloni, and I'll be taking over as the moderator for today. Okay, so up next, we have an amazing mentor as well. Please make welcome Mr. Christian Anoku to take and give us his opening statement on today's topic. Over to you, Mr. Christian. Do we have Mr. Christian? I can still see him. Hello, Mr. Christian. Okay, please, can anyone else hear me? I want to be sure that it's not network interference.
Yes, we can hear
very
you.
audible.
Yeah, it got slow. Yeah,
Okay,
audible.
thank you. Okay, thank you very much. Okay, then we'll move then of IP. Let's hear from him now, his introduction. Mr. Mark, it's been quite a while. Good evening, welcome to today's discussion. Let's get your introduction on the topic. Thank you so much, sir.
God's love, good to see you again. Apologies,
You
my
too,
place is a
sir.
little dark at the moment, so I'm sure you might not be able to see me too clearly, but it's good to be back again on Jiipcc, and God's love is always good to see you. And of course, let me acknowledge, as usual, the organizers of Jiipcc for always having me back on the program. I think it's always mutually beneficial, even to us, even though we are called the mentors, but a lot of times, even the mentees are able to bring insights, ask questions that would actually we also find really beneficial. And let me also acknowledge Onyekachi, who just spoke before me, for that very insightful presentation. Well done, Ma. So I'll just, for sake of time, speak very briefly. I want to particularly look at the enforcement part of our topic today, because registering your IP, of course, is a first step. Being able to determine when there has been an infringement also is another critically important step. But if you have now determined that your IP is registered, it's been infringed, then of course the real deal now is how to enforce that right, and to ensure that your IP right is respected. You are able to keep out the third parties from further eating into your income. Or, like I would always tell people, remember that when an IP infringement happens, what the infringer is doing to you is beyond merely, in a sense, stealing your money. Because if I'm able to, put up a bottle of water or a bottle of soft drink, and I put the word Coca-Cola on it, it means the first level, that's an infringement, obviously, of the famous Coca-Cola brand. But the first level of the harm that I'm doing to Coca-Cola, essentially, in selling that bottle to anyone, is that someone who has come to buy a bottle of Coke, how much is a bottle of Coke now, God's love? Is it still 100 naira, 200 naira, or maybe 500 naira? Because Nigeria now, you never can tell what the
They are
current
different sizes.
But how much is the average, the standard size? That used to be 100 naira before, normally.
I think it's 250 now. It is 250
Wow.
now. And then the bigger one is 400.
Crazy, crazy, crazy. So So you can imagine that the first thing I'll be doing to Coca-Cola when I infringe on their trademark by selling that bottle, that is not from them, is that I've stolen that 250 naira that should have gone to Coca-Cola, because the person who comes to buy thinks he's buying a bottle of Coca-Cola, whereas he's buying something, a counterfeit product from me. So the first layer of harm that Coca-Cola suffers in that transaction is that they have lost 250 naira. But the second layer, which is even more important, is that when the person drinks that concoction I've put in that bottle, I mean, it doesn't taste like Coke. It tastes really bad. It's really poor in the taste. And the person is like, wow, Coca-Cola have really lost it. They no longer are maintaining their standards. So he's going to tell someone else that, I bought a bottle of Coca-Cola and it was not it at all. So by doing that, now you can see that the second layer now is that Coca-Cola has lost the 250 naira. But in addition to that, I've tarnished their brand. I've made other people who would buy Coca-Cola tomorrow say, look, we would no longer buy Coke. So in addition to the initial loss of my 250, Coke is potentially going to lose a lot more from other people who I tell about, my bad experience with that Coca-Cola. So, it's always important to be at the back of your mind that the primary harm that a brand owner suffers is the loss of revenue, but the secondary harm suffers is that tarnishment, which sometimes is worse than the actual loss of revenue, because tarnishment also leads to further and unquantifiable losses of revenue. So if you have determined that your brand has been infringed, so Godzo, just confirm, how many minutes do I have for this? I know Unika already took 15 minutes.
Okay, yes, sir. We can do 10 for the opening so we can have more time to discuss after the
I'll even
presentation.
try to cut down. Okay, thank you, but I'll try to cut down. I think I've spoken for already 3 minutes, so I'll try to wrap up in 2 minutes, just so we have more time to look at the mentee's presentation, and then, of course, we would engage more at Q&A level. So just to broadly say that after you have determined that the person has infringed on your right, enforcement is a range of actions. Enforcement, for instance, would involve making a report to regulatory agencies. So it's also possible to use law enforcement, for instance, or even other quasi-law enforcement like the Federal Competition and Consumer Protection Council to also help you, for instance, conduct a raid and shut down the operations of the infringer. And of course, you can also take out a court action, which is the quintessential way to enforce your IP right, because you want to get the court to award you damages, you want to get the court to grant an injunction against the infringer, you want to get the court to order them to account for the profits they have made off of your brand, and then so many other things. Also, there are alternative disposition measures you could also bring in at some level. Mediation and arbitration could also be used to help enforce your right, even though they are issued with using particularly arbitration to enforce IP rights. It's an open debate, but we'll discuss more about that as we go along. But just like I've said, all I want to take away from my from my introduction is just the fact that enforcement, registration is important, but it's not absolutely necessary. So you know that, for instance, with copyright, you might still be able to enforce, because your right endures even without registration. But however, registration is important. Where you need to register, of course, always register before you move on to, and then when you register, don't go to sleep. You need to police your brand to know when there's been an infringement before you can move to enforcement. So when we discuss more, we'll get into some of the details how to enforce. Thank you, God's love, and back to you.
Okay, thank you so much, sir. It's always a pleasure hearing you speak. Thank you again. So, ladies and gentlemen, please, in the chat box, do not forget, this is a very interactive session. We have mentors here. One thing about them is they would interact as much as you give them that energy. So the chat box must not be empty. If there are things our mentors are saying that make so much sense to you, please include it there. Let's get the chat box busy. Do not forget, we're also scoring you based on your participation in classes. You want that certificate at the end of this program, right? You need to earn it. So please, let's get the chat box working. Let's see that you're really benefiting from everything our mentors are saying. Okay, Mr. Max said something about policing it. So if there's one person who sows the idea about create it, protect it, police it, monetize it, and the word, once you use Owoni Koko, I cannot forget that. So when IP comes into my mind, it's always create it, protect it, police it, monetize it, and all that. Ladies and gentlemen, our next mentor for today is the beautiful, wonderful goddess of IP, like I've dubbed her already. Please let's make welcome Mrs. Shukura Almosa to take us on her introduction. You're welcome, ma'am. Okay. Unfortunately, she can't speak now. Okay, ma'am. But thank you. It's an honor having you in the session. I don't think Mr. Christian is also available at the moment. I have sent him. Okay, ma'am. I have sent him a private message already. I'm yet to get a reply on that. Anyway, I think we'll move straight on to our mentees for their presentations. So mentees, please, the moment to call on you, kindly start off. Group one, once group two rather, once group one is done, take off with your presentation. So once start off with group one, please, are you ready for your presentation? I believe you are. Please, the floor is yours. Who is the presenter for group one, please? Hello, groups. Please, is there a backup presenter as well? Is there anyone in group one, please? Kindly. Okay, hello, Saint Ame. Are you the one presenting today, please?
No, I'm presenting for group 2. Just greeting you. It's not your time.
Okay. Please, who are those in group one? We need that right now. Group one, you need to have a presentation now. Please, group one members, kindly identify in the chat box immediately. Thank you. Okay, so while group one will be probably having some issues very soon with management, we want to go to group two to give us their presentation. Thank you for being on standby. Please, over to you, group two. Let us have your presentation. Thank you.
All right. Good day, everyone. Good day, Mr. God's Love. Good day, mentors and my fellow mentees. I'm from group 2, Saint Ame, and I'm going to be presenting on behalf of the group, and I'm also going to be sharing my screen. I'm the backup presenter. So I'm going to be sharing my screen now. I don't know if you could see my screen already. Hello, can you see my screen already?
No, not yet.
All right. Sorry about that. I'm setting it up now. Yeah. Or should I just go on? I don't know why.
I was going to say, while you're probably trying to set up, you can actually start off with the presentation. Please, if there's anyone in group two who could help with the slide, please help him to navigate the slide. Thank you.
All right, thank you so much. Well, I'm going to be presenting on intellectual property enforcement, and Mr. Marks just did justice to that. Thank you so much, Mr. Marks. And when you talk about enforcement, how many minutes do I have, please?
You have 7 minutes, please.
Oh, well. All right, sir. And when you talk about enforcement, it actually revolves around safeguarding intellectual property, intangible assets, IP rights, enabling creators to secure protection for their creative and innovative endeavors. Mr. Marks just explained that in details now. It doesn't stop at registration, it doesn't stop at infringement. You have to go on and determine the right. So we have basically 2 forms of intellectual property enforcement: the physical enforcement options and the online enforcement options. Talking about the physical enforcement options, what that means is you can determine your rights physically, you can enforce it physically by We have three methods here, or three ways: by cease and desist letters, by injunction, and remedies. Just as, for example, monetary damages and all that. So I'm going to be explaining the cease and desist letters now. As the name implies, immediately you feel, or if it is determined that your right has been infringed, you can physically enforce it by the cease and desist letters, by clearly identifying the IP that has been infringed on, giving detailed evidence to the support of infringement claim. Then talking about the injunction is actually a court order restraining someone from doing or reframing someone, ordering someone from reframing, from doing a thing. So if your right has been infringed on, you can apply to the court for an injunction to stop the further infringement. And talking about the remedies, we have the monetary damages. That's the compensation, or the money you get out, or the money you get from the infringer at the end of the day, when the court has determined that such a person has actually infringed on your right. So in order to be more practical, I'm going to be we have three cases to illustrate the physical enforcement. What are the judicial authorities, or the examples that shows that people actually resort to this very method of enforcement? We have the case of Mumbo Entertainment versus Baby Boss. We have Beddings Holdings Limited versus INEC, and we have the recent Balaikas case. But I'm going to be discussing the Holdings Limited's case versus INEC. And in that case, Beddings Holdings Limited sued INEC for infringement of its patent in the process and application of the direct digital capture machines for the compilation of collection of various biometric information granted under the Patent and Design Act. So INEC, Beddings were actually alleging that INEC infringed on their right. And at the end of the day, the Federal High Court found INEC guilty of same and ordered that INEC, pay Bedding Holdings the sum of 17.3 billion naira in damages. That's quite a lot. So that's actually a practical example. Then the second phase down is going to be the online enforcement options. You don't only have the physical enforcement options. You can also take measures like, the takedown request. Prima facie, as the name implies, ordering the infringer to take down the contents that have infringed on your right. Then we also have the online dispute resolution platforms, such as eBay Vero on eBay and YouTube Content ID on YouTube, and so on and so forth. And equally, we also have case studies on online enforcement options. A very good example is the digital rights management. The digital right management can be used as an enforcement. A good example also to relate to this point is that Ubisoft uses DRM. DRM is the short form of digital right management to protect its games like Assassin's Creed, to avoid unauthorized copying and distribution. That can also be seen as one of these policing mechanisms, as Mr. Marx rightly explained earlier. So the last phase of this presentation is going to be the arbitrability of intellectual disputes. Arbitration is actually one form of ADR, that's the alternative dispute resolutions. And arbitration is actually a means or a mechanism for sorting out issues or disputes other than using the court or litigation method, and it is usually done by a third neutral party. Then what are the elements of arbitrability of intellectual and property disputes? You must actually show that your rights have been infringed upon, and both parties must present. There must be an arbitrator, that's the neutral third party, and there must be an award at the end of the day, and it's usually binding amongst the parties. So now we have IP issues that can be resolved. When you talk about copyright now, when there is a copyright dispute, it can actually be resolved by arbitration. And Section 37, subsection 7 of the Copyright Act 2022 settles that. The section provides to the effect that where a party, are having disputes with regards to copyright, they can resort to arbitration. So that's that for copyrights. And the other IP methods are patents and trademark disputes. This when disputes arise in these areas, they can be settled by arbitration. And there are actually several benefits of arbitration in settling disputes. It actually it's neutral because you are bringing the third party who it's actually neutral, and there's an award at the end of the day. There's confidentiality. You don't have to spill out the whole matter to the whole world. It's confidential most of the times. So lastly, we actually have challenges of arbitration for intellectual disputes in Nigeria and IP disputes. The fact is, intellectual property conflicts in criminal nature are actually not arbitrable. Yeah, the law has provided it that way. It's not arbitrable when it comes to criminal matter, except for civil matters. And consent is usually very crucial. Both parties must agree. So with this, we've come to the end of our presentation, and I hope we follow through. Thank you so much, everyone.
Thank you so much, Saint Ami. For a backup presenter, that was a great presentation. Thank you so much. I really enjoyed that presentation, and I believe our mentors also enjoyed that presentation. Mentees, please do not forget, yes, just upload him in the comments and the chat box. He did a great job with that presentation. Thank you so much. Okay, do we have group one ready for their presentation now? Please, do we have group one ready for their presentation now? Okay. Sorry, mentors, it seems one of our groups will be able to present today. So quickly go back to our mentors to get more wisdom from them. So please, I'll be coming back to the beautiful Miss Jiipcc to get and to confirm. Okay, so Onyekachi, I'm sorry. To confirm, let us get to know your take on the presentation as well as the slides you got before. Then I think let's start from there. Let's get your take on the presentation as well as the slides you had earlier gotten from our mentees. Thank you. Hello, please. Can you all hear me still?
We can, God's
Yes, God's love, we can. So, sorry,
Okay,
God's love, I just want
okay.
to confirm. Are we already getting to the point of, have all the groups presented? I thought I saw only two groups.
Exactly, but just one group presented. The other group, nobody's available at the moment to take on their presentation. So we're moving back to the mentors now.
Okay, so to comment on the presentations and then take questions and answers.
Yes, sir.
Okay.
So, okay, so I think the floor is yours now, sir. You can give us your take on the presentation as well as the slides you got earlier. I'm really happy that they gave us some recent Nigerian cases. That was really, really a nice one, I think, from the presentation I heard. So over to you, sir.
Okay, yeah, thanks. Yeah, so I mean, I looked at the slides and I thought they were quite good. I agree with you also that it was showed that the group actually took their time to do some research and really current and updated research as well. I mean, of course, I look forward to when we get to the Q&A to dig in a little bit more into it. But I wanted to point out particularly on I believe that was the last slide, if you can pull it up again. I believe that was the last slide that talked about the challenges of IP and arbitration. I wanted to just make a few comments about that. It's actually a really hot issue when it comes to the use of arbitration to resolve intellectual property disputes. Now, there are a range of arguments. The first of that argument is a constitutional point. I mean, for those who are familiar with Nigerian constitutional law, because we are a federation, therefore we have a very strict sharing of powers between the federal government and the state government. One of the results of that is that we have a sharing, there's a list attached to the constitution called the exclusive legislative list and the residual legislative list. So the exclusive legislative list lists the things that are within the exclusive powers of the federal government. And by that same token also, the court system at the federal and the state level also have the same division, the same division of powers as well. So, okay, I can see that I'm already pointed out here. So section 251 of the Constitution, so the first layer of the argument is that because section 251 of the Constitution gives exclusive right in intellectual property matters to the Federal High Court, therefore the argument, yeah, correct, thank you, St. Ame, for that, yes, paragraph F of 251, 1F, says, so the first layer of the argument people have made is that only the Federal High Court has jurisdiction over intellectual property matters. Therefore, arbitral tribunals do not have jurisdiction. But thankfully, that argument has been debunked, because the reason is that arbitration is simply the courts. Arbitration does not divest the court of jurisdiction. What a court does when a dispute that contains an arbitration agreement comes before the court is that the court exercises jurisdiction to make the parties go to arbitration to resolve their dispute. But it doesn't mean that the court strip itself of jurisdiction. You understand? So based on that argument, the argument that section 251 would prevent parties from being able to arbitrate IP disputes is no longer an argument that holds water. Because if that argument holds water, then a lot of disputes will no longer be arbitrable. Because, for instance, oil and gas is an exclusive matter also within that same section 251. But yet, oil and gas disputes can be resolved through arbitration. The only disputes you cannot resolve through arbitration are disputes that are not arbitrable, possibly on public policy grounds. So, for instance, taxation has been made clear that taxation disputes cannot be resolved through arbitration. And that is on public policy grounds, not because of exclusive jurisdiction of the Federal High Court. But there's a second layer to the argument about arbitration of IP disputes. It is now that, for instance, patent is a monopoly granted by government on public policy grounds to an inventor. And the public policy consideration there is that after 20 years, or when the monopoly expires, that invention should become available to the entire public to work it for the benefit of society. So there's a public policy element in the grant of patent. So based on that, the argument is that an arbitration tribunal should not have the right to now determine the validity or otherwise of a patent, because by doing that, that arbitral institution is now tampering with public policy considerations that lie underneath the grant of a patent. So that is quite a legitimate argument. But you can see that in as much as that is legitimate in patents, it may not hold sway in copyrights, because with copyrights, the right use without government having to grant you any registration. The registration doesn't, you don't require registration, sorry, for your copyright to become enforceable. So you can see that with copyrights, for instance, that public policy element may not be there. So that's why the argument is that when it comes to arbitration of IP disputes, not every IP right is not arbitrable. So copyright, particularly the contractual aspects of copyright, such as licensing agreements and all, can be resolved by arbitration. Now, if you look globally, different jurisdictions have different approaches to arbitration of IP disputes. Some are very strict, so it is complete. There's a complete lack of right to arbitrate IP disputes. Some are middle way, like I would argue that in Nigeria, middle way. So some IP disputes can be arbitrated, some cannot be. So arbitration that touches on the validity of IP disputes in Nigeria, of IP rights in Nigeria, such as the validity of the grant of a patent, the validity of a trademark, the grant of a trademark, those would not be subject to arbitration. But if the dispute is on commercial agreements arising from the IP rights, such as licensing, then you can arbitrate them. But in some jurisdictions, like Switzerland, for instance, all IP disputes are arbitrable. So even the grant and the validity of a patent can, be arbitrated as well. So it's quite a dicey. It's
I think we're having some issues with network from Mr. Martis. And
my apologies. I got cut off briefly, but I think I'll just end my thoughts here. Yeah, just to point out, like I said, that yes, there's some method of enforcing IP rights through criminal action. That's also. Let me just make that point. Thank you.
Okay, sir, thank you so much. Thank you. Okay, we also have our other mentor, the beautiful Jiipcc, is still on the call of discussion with us. So over to you, ma'am. Let's also get your insights on the presentation as well as the slides sent in earlier by the mentees. Thank you.
All right, thank you so much, God's love. Your name reminds me of the love of God. I want to say thank you to the presenter. That was a beautiful presentation. I appreciate that it was apt and detailed. And then it covered all aspects one needs to know about enforcement. So when I read through your slide or the material you sent earlier, I didn't have issues with that aspect of the slide that was shared with me. However, let's recall that there are supposed to be two different groups. What was supposed to be like the intro to this next topic. So for the purpose of those listening, and in order for them to go home with a full package, I want to dwell more, since Max has spoken on this other presentation, I'd like to dwell more on the other part. In fact, the main reason I decided to put up a slide very quickly this evening or this afternoon was because of the first slide or the first material on the intro. It looked more like the group. I don't know if IP meant only copyright to them. That's why I needed to quickly do a little background to now say there are majorly two aspects to intellectual property rights. Apart from maybe intellectual property itself, the rights being grouped into two, where you have communal rights and personal rights. It now goes forward to further to break down the personal right into the registration aspects, where you now have copyright and related rights. So when you are discussing only copyright and related rights, what happens to the industrial property rights? So that was why I went that low, and then decided to now come back to infringement. Because for me, if you're aware that you have a lot to lose, if you know that you created a right and then you want to put it out there in the open, in the market, and you know people are going to feast on it if you don't put a protection. Let's take it this way. There is a tree in your compound, and then because it is fenced in, it's a mango tree. Remember, it's season for mangoes. No one can have access to this mango tree. Nobody can pluck from the fruits. Nobody can eat of it. It's exclusive to you for your enjoyment. So it's only you can decide to pick up the fruits, take them to the market and sell, to eat them by yourself, to give out to neighbors. Why? Because it is fenced in. Now, the same scenario, place this tree in the middle of the market or outside of your fenced property and passerbys, because you can't always be outside. And even if you are, how many can you pick up at the same time? How many people can you chase away? So it's the same way intellectual property is designed to protect people's creativity, which we want to call creation of the mind. Whatever makes you to sit down to conceive an idea, what should you do next? I may not necessarily belong to the school of thought that says once an IP right is created, I run off to go and register. Sometimes some people believe, why don't I test it in the market first? Why don't I decide on the name I want to use? So you have instances where a business starts off with a particular name and later decides to change the name. So imagine they're taking up IP registration. So it's a trading. It means they now have to abandon that old name to move on to a new name. And that is incurring extra expenses. So sometimes a business might want to trade for at least 6 months or thereabout before going to register. Of course, there are dangers to it. Also, you find businesses that take up maybe their CAC registration without knowing about intellectual property. So out of ignorance, they decide to operate. They're operating for some time before someone else tells them, oh, there's something called intellectual property, trademark, copyright, industrial design, and then they come back to what to register those. As another instance where a business can take up without IP registration. For some, they learn the hard way until infringement sets in. This is why, for me, protection doesn't come first. It can be the other way around. And in fact, I enjoy it more when it's the other way around, before protection. So, but like I said, there are different school of thoughts to IP. Whichever angle you come from, just be able to defend it. So going forward into infringement. Today at time, because that slide dwelt more on digital economy, talking about copyrights. So that's why I decided to talk about that as well. So even in the digital space, he limited most of the things on the slide to just music, books, as aspects of copyright. So I try to bring that angle that today you have so many people trading from their bedrooms and selling products as far as in UK, US, or even Nigeria, or other parts of Africa. Yet they don't even have a physical store. That is the power of intellectual property. That is the power of digital space. So the digital space has now made our markets smaller compared to what it used to be before. Before now, I might have to go to Alaba International Market to purchase my electronics. So today, from my bedroom in here in Abuja, I can decide to place an order, maybe through any of these popular online stores, maybe like GG and all that. And then I get my products within maybe a few days delivered to my house. On the other part, you have people who now go to the digital space to cause a lot of harm. I don't know if anybody has been duped here before, maybe on Facebook. You see products, oh, hair growing products, buy 300,000, tested and trusted. And then you think it's real. You credit these people, and then they don't deliver anything to you. That's a form of infringement because the product actually exists somewhere. And then for some people, even after you paid for the product, what I ordered versus what I bought. I'm sure you've also heard that statement online. So these are some of the disadvantages to trading online. Then when we narrow it down to even the music, that is the most popular aspect of copyright, considering our time. You see so many people download people's work, songs, and then we all enjoy it from our various homes. People share to us, we also listen to them, breaking bounds, infringing on people's products or someone else's music, denying the person the gains he would have made. And then we are crediting our own self because we have shared it on our platform. So YouTube is perhaps paying us some token because of the number of shares and likes we've gotten so far. So we have denied the IP right owner. So what happens? What's the effect of this? If you deny me my rights, because I sat down to create it, remember, it's the creativity of the mind. It's first the creativity of the mind before the creativity of the hands. So what it means is I sat down to think about it. Inventors are deep thinkers. They spend time thinking going through experiments, going to the lab to create and make mistakes and go back again and not giving up. Some, it took them 10 years to develop a particular product, or to come up with a song, it took them months. And then within a twinkle of an eye, you decide to make a mess of it and channel the money to yourself. What do you think happens to this inventor, right creator, designer? They give up on faith. They'll say, this is what it is. If nobody's going to protect me, if people are not going to respect my rights, why go back to think more? Why do I want to keep creating so people keep making a mess of my right and denying me of my entitlement? So you see, you have discouraged the creator. On the other part, like Max already said, he's my respectable brother. We've always had to meet on forums like this, and I always enjoy when he speaks on intellectual property. So what also happens to such a person is this. You have diluted what this person has created. You use the instance of Coca-Cola. When you drink the poison, tomorrow you'll be like, this is the taste of Coke, I don't buy again. Or maybe the thing upsets your stomach. You'll be like, what is this? I'm not going to patronize this person again. Now, taking it further to enforcement, that act of making people drink the wrong thing, thinking is another person's brand, number one, you've diluted the brand. You've made customers to lose faith in the brand. So they won't want to patronize the brand. You've diverted income to yourself, making the brand owner begin to regret, why did I waste my time? And then more importantly, when your products, your fake counterfeit products, causes damage to people, ill health, or someone dies, hope you know it's a criminal offense. So when we talk about enforcement, it's not only civil suits, it can also be criminal suits, especially where crime is committed. So imagine all these people that go to China to import fake pharmaceutical drugs, and they end up killing babies, children, pregnant women. And then it strays to you. By way of enforcement, it can be a criminal case, not just a litigation like a civil suit, no. And then this time around, arbitration will not help you, because the criminal matter is government that will come after you because you have killed people. So these are some of the disadvantages. Why a right holder must build a fence. Build a fence in, protect what you have created, not just so that you don't lose out, but so that people don't dilute your brand. And more importantly, so that your product is not assumed to be the one causing harm to people out there. So these are some of the reasons, not just for yourself, but for the general public. So you hold people this right. So it's one of the reasons why you should get protected. And government will not necessarily act on your behalf. It's your tool of registration that will make government say, oh, you are protected because you registered with government. And so government is going to stand behind you to make sure we enforce your right. Now, the aspect of policing is also a beautiful aspect of checking out who is making use of what in the market. But for me, the first step will always be opposition. How do I use opposition to enforce my rights? Let's take, for instance, it is trademark. And you have registered your trademark. Are you keeping an eye, or did you just register and go to sleep? After registration, you'll have journal publication. Are you always checking those journals to know if somebody else is coming close to your mark? Maybe you registered, say, Papillon as a product, say in class 32. Maybe you're using Papillon for water, juice, and all that in that class. And then somebody else comes with the name Papillon. Maybe the spelling is altered by just the last vowel. Maybe yours is U, and this new registrant is O. But you agree with me, they look alike. So if I go to market to want to buy, say, juice called Papillon, I'm then going to stretch my hands and just pick up Papillon, not knowing it's not Papillon. Why? Because they look alike, they sound alike. And some people can be so dangerous. They stylize the mark alike, meaning the style with which they write out the Papillon. It'll be so close. And then the dressing of the juice too, which is industrial design, might be so close to the dressing of your own juice, which makes it even hard for consumer to be able to distinguish the two of them. So this is why the registry, one of the major functions of an examiner, is to say no to the second registration, to then say there's a similar mark cited. Hence, we can't register this mark. Consider bringing another name or the mark is rejected. So you have instances like that. So for me, opposition is the number one. And if the person goes ahead to file the mark, that is not going to change the name, and he files. And then I cite it either through my lawyers or I decide to go through the journal publication, then I'm going to write to the registrar to then say, Mr. Registrar, I call your attention to my registration, attach my maybe acceptance letter and maybe my trademark certificate, indicating that I have registered this mark. Please let me use this opportunity to say that if you file a trademark and decide to stop at the stage of acceptance, you don't have a certificate. Be well informed that you are here to register a mark. At best, what you have is intention to register. You can be a right under common law, but it can't be enforced because it's just the mere intention. What gives you right to go to court and then say somebody infringed on my mark is a registration certificate that you get at the end after opposition period. If your mark is not opposed, or it is opposed and you go through it successfully, and then the registrar awards you a certificate, then that is what grants you the right to then say, okay, I have a mark. So people should know this and let others know as well. So moving forward to patent, opposition can also happen in patent. In fact, you can have pre-grants opposition. What is the pre-grant opposition? Unfortunately, we don't do search as to substance. However, that doesn't mean we don't consider pre-grant opposition. But someone will say because we don't publish patent journals, that is equally difficult. No doubt, that is equally difficult. But most of the time, patent agents hang around the office. So they get clues or they get to know somebody wants to register this, and we have registered something similar, or we have a registration in Nigeria that should bar this other one from being imported into Nigeria. And so they'll come and give the ins to the examiner to say, oh, we noticed this. Could you keep an eye? Can we have more details? We think this person wants to infringe on our patent, and they can actually bring a position, and it can be considered. So it gives us more literature to consider when we want to grant a patent, when we want to decide whether to grant or to refuse a patent application. So for me, this is the first step, and is cost effective. Also, there's something we call administrative panel at the Patent and Designs Registry, which is similar to opposition tribunal for trademarks. So what happens with this? I know people like Maxi Conga, I think heard him make a statement like this before. I'm not sure if he's one of those, but I know you might take me up on this to say, oh, it's not in the statute. Let me start by saying that even in that aspect, the current act we're using empowers the minister and the chief registrar of patents and design to make or to vary the provisions of the act to some extent based on what is evolving, based on what is happening out there, so that we too are internationally compliant to what is going on. Don't forget, we're not just IP office, we are representing Nigeria IP office. So if what is happening in the UK, the US, globally is making sense, that they're already changing in some areas, and some countries use policies such as China, we don't necessarily have to wait for the statute to be 100% changed. We can ride on that provision to then say the minister is empowered to create the administrative panel. What happens in the administrative panel, especially we use it especially for industrial designs, where somebody has made a design and another person wants to register a similar design in the office. And because in the market, there's what they call trade unions in the market, this is another level of enforcement before we begin to think of civil litigations and whatnot. And I love this aspect of trade union. So it's what even informs our administrative panel. So let me quickly talk about that. So take, for instance, the Alaba market. You have somebody who is selling maybe a particular form of electronics, and then somebody else comes to design a similar mark. This person takes it back to the market and wants to start selling. The trade union would confiscate your goods. They will insist you change your wrapper, which is your design, registration, and all that. Or they would insist you go and withdraw what you have registered, that you can't sell it in the same market where they are, because the two parties are members of the market, they have equal rights and they're equally protected by the trade union. And so the trade union will consider who came first, who brought this product first into Nigeria, who brought it first into the markets. And when they see A is the first to import that particular product, or the first to go to China to design this product to bring it to the country, they insist that B must shift his hands or change the name, change the wrapper design, or alter the design. And they don't care what's going to cost you to do all those. That's the power of the trade union. So I would say any business you're into, don't trade alone. Join trade union. Be a member of one union group. It's like labor force. People will come out and fight. When you come out to fight alone on your own, you might not really get as much support as when it's a whole market coming together to say, okay, we are closing down this your store until you comply. And this is what we have decided. Go back to the registry and change. So sometimes they do us a letter to say, we noticed Mr. B has come to register a particular product, and he infringes on Mr. A's product, and they're both members of this trade union and are bound by the decision of the trade union. Therefore, Chief Registrar, we seek your indulgence to consider canceling this other matter. So sometimes the Chief Registrar will write them back, invite the parties with witnesses, and then they form what we call this administrative panel, with, of course, members of the registry. And then we hear both parties. But this administrative panel, in as much as it is being criticized, is done wonders too. Because from that place, like I remember a particular case we handled some years back, it had to do with a boss in the market who had designed a particular footwear. And so another of his boy, because he didn't even register in his own case, but of course it was known in the market. There's all these old traders who didn't know about registration. So one of his boys decided that he settled years after, moved to another location, away from the same markets, by the way, and created the same design and came to register in the office so that I can block the dogger from further exercising his rights. If you ask me, that's number one form of wickedness. Somebody whom you have trained is like an apprentice, whom you trained under your care. You gave him the expertise, you taught him all he knows, he goes to stab you in the back. So that is not even good. In this instance, despite the fact that this other person didn't have a registration, they used the trade union to fight this new registration to the point that it frustrated him out of the market. And he couldn't survive. So by the time they got to the registry, even our hands were tied. This is the person who has registered. So they came saying, but it's not a new design. This design has been in the market for years. So the registry didn't know it's been in the market for years. So based on that, we agreed with them and canceled this new registration, allowing the older person to now take up registration. That's one part. Another example I want to talk about, using the same footwear, that I recall that happened. Two independent designers made their designs. It was quite similar. A claimed he didn't know of B's existence. And then one is in Onitsha, or Ziaba, and the other one is operating maybe in Osun State, if I can recall the details very well. So it was like in the east and the southwest. And so when they came together before the tribunal, we found out that it looks to some extent that they are operating independent of the other, and they don't even know of the existence of the other person. So they decided and came to a conclusion. Okay, since you are designing this and you are selling in the east, and I don't even have coverage in the southwest, and I am designing in the southwest and I don't even have an extension in the southeast, can we then independently continue to be in the same market such that you're operating in the southeast and I continue to operate in the southwest? So it was resolved like that. So there are issues that you don't even need to go to. Don't forget the court system. You don't know when it's going to end. It takes years. And that's why we always say, okay, AGR, an administrative panel, opposition panel, that just like what a form of maybe mediation or arbitration whatsoever. Just that you don't have an arbitrator, but you have someone mediating in the person of the registrar or another staff appointed to act in that capacity. I'm going to stop here right now, so thank you. I'll still stay around in case you need me again.
Thank you so much. Thank you. Okay, network, thank you. Thank you so much, ma'am, for that beautiful. It's like every day, every time I hear mentors speak here at Jiipcc, it just gives me new insights into the amazing knowledge we have when it comes to intellectual property. Thank you so much. Okay, mentees, our mentors have been exceptional. Basically, today's topic is into three broad parts: the registration, the infringement, and the enforcement. So I want to leave the floor open to questions to my mentees. Please, if you have a question, just use the raise of hand emoji and we'll call you to ask your question live. You can do that, yes. So we have our mentors here. They can answer any question you have and you need clarification on. A lot has been said so much about infringement and enforcement. So ask, how about the registration proper? So you could say something about letter of acknowledgement. A lot of people get that a lot. I know someone had told me in the past when he does trademark for a client, it just takes him 2 weeks. So 2 weeks in this country, okay. I wonder what you'll be giving to your clients all this while. So imagine he has worked for over 20 clients. So that means there are 20 people. Perfect. Okay. So there are over 20 people who have registered and not registered at the same time. Okay, ladies and gentlemen, at this point, I'm so glad to announce that the goddess of IP is with us and she's able to speak now. So in that regard, we just will give the floor to Mrs. Shukurat Mosa Modupaola to give us probably her introduction, her take on the position, and as well as talk about IP registration, infringement, and enforcement. Please, ma, the floor is yours. Welcome again.
Hi, hello everyone. Thank you, God's love, for the warm introduction. I don't know where you get this what do you call it, just from. So sorry I took time. I was out. I'm just entering. So first I would like to comment on the presentation. Then when my slide loads, then I'll probably take my presentation if time permits. I was on the call all through, so I heard Kachi and Oga Max speak about the presentation, and I think they've done, in fact, they've done amazingly well. But I'm just going to add one or two things. And first off, I would like to talk on the other, I think group one that didn't present, right? It was group one that didn't present, if I'm right.
Yes. Group one did not present.
And I'm sure we have members of group one.
Yes, you're very right. You're right.
Right? Okay, that's good. So I would like to start from there because this is not the first time this is happening. I think we had the other class last week on patent drafting, and because the person that was supposed to present wasn't available, there was no one in the group that could present. So I'm going to say that you are doing yourself a disservice by not coming forth to present, even when the main speaker is unavailable. You joining Jiipcc is not just for you to only learn IP. You can do so many things by joining this program if you actually participate 100%. Because you also have the opportunity to boost your morale, boost your self awareness. You can speak, and you also have that confidence to come out and talk. But when you just come, you contribute to the presentation in the group, but you don't want to come outside to speak. You don't want to ask questions. If the person that's supposed to present is not available, then nobody wants to take it. It shouldn't be like that. It's a group work. Okay, I think my system is on now. So I'll log out from here and join on the other one.
Okay, so mentees, while we wait for her. Yes, I can hear you.
Okay, that's good. So as I was saying, when somebody is not available or probably during your meeting, have at least 2 or 3 backup speakers who can do the job. You don't have to be perfect, right? Just speak to your presentation and be able to clarify. Even if you make mistake, we are going to correct you. Okay, so just try as much as possible to be able to communicate. That's all. It's not a do or die affair. You're also building yourself. Okay, so today henceforth, we wouldn't like to hear, oh, group one is not available or the speaker is not available. Imagine if the mentors are here. You're not encouraging the mentors if the groups that are meant to present are not available. Okay, so I'm going to leave it at that. Then for group one, for group two rather, I went to presentation and they did an amazing job. In fact, I love the slides. Just that I would say the topic for today is about intellectual property registration, infringement, and enforcement. So what I will say is that probably maybe that was the topic they were given, but next time you should try to connect these three together. So you start from registration, you speak on how registration links to infringement, that if you don't register your right, somebody might infringe, or even if you register, they can still infringe. Now, when you have someone that has infringed on your right, what can you do? And that will now lead you to probably enforcing your right. So just that link is not there. You didn't link registration to infringement and enforcement. So let's assume we have a new mentor who hasn't been in the program before. Like, I understand you've done IP registration in the previous sessions, right? So I understand that you've touched that. But let's assume we have a new mentor on the call. The person might not understand where you're coming from. You just presented on enforcement, and your topic says IP infringement, enforcement, and registration. Okay, so then I'll speak on. During your presentation, you mentioned ADR, but there was nothing about mediation. You only focused on arbitration. I think mediation is also an alternative dispute resolution. So you didn't speak on mediation at all. So you focused everything on arbitration, of which mediation is something you can also do if you don't want to go the length of arbitration. I think those are the two things I noticed during that. And I also mentioned that, yes, even presently, we have a dispute board to arbitrate copyrighted works. WIPO and NCC, they have a board that on just like dispute resolution for copyrighted works in Nigeria. We have that already. And just like Kachi said, you can go the route of administrative for patent and also trademark. So I'm going to share my screen now and just briefly run through my presentation. Then we can take questions. Let me know when you can see my slide, please. God's love.
Okay, yes, you can see it now.
You can see, right?
Yes, I can. It's visible now.
Okay.
Yes. Thank you.
Okay. So the topic is about intellectual property infringement, IP registration, infringement, and enforcement. So just like what we have here, right? IP registration and you have IP infringement. So this person in the middle is the person that is trying to, or this pencil in the middle is trying to infringe your IP rights. But you know that when you have registration and we have a good enforcement system on ground, then there's nobody can actually break that bound. So we're saying what the law has joined together, let no infringer put asunder. Right, so we'll talk about IP overview, IP registration, IP infringement, then we'll finally round it up with IP enforcement. So I won't go deep into it because they've mentioned it before. So what do? This is the overview now. You have an idea. That idea, the first thing you have to do is to create it. Because you have an idea in your head. An idea in your head cannot be protected. You have to put that idea in paper or put it somewhere. Now, doing that is you creating that idea. Now, when you've created that idea, you should now be able to identify, okay, this idea they have created, what category of IP does it fall under? Is it a copyright? Is it patent? Is it trademark? Is it trade secret? Is it GI? Is it this? Blah, 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 blah. So when you are able to identify what category this falls under, then you can now decide, is it a registrable right or a non-registrable right? So for example, copyright is more like a non-registrable right because you really don't have to register it, although it's important and necessary, not compulsory for you to register, right? So when you're able to identify the kind of right you have, then you decide if it's a right that you should register or a right that you should not register. For example, trade secret, you can't register that, right? Now you've registered your rights. Now you've registered your rights. You're using it, and then somebody is also using this right without your permission.
Somebody using your right without a permission. If you don't police your rights, there's no way you will know that somebody is using your IP rights without your permission. So like I always say, registration is not the bus stop. The fact that you register your right doesn't mean, oh, you are done with everything. In fact, you're just getting started, because anything that is good, anything that is making money, definitely somebody will want to, benefit from it, right? So as an IP rights holder, you are the first police to your work. If you don't police, the government will not form a police for you. It is when you policed it to a certain point and you've seen someone that is now infringing, then you now want to enforce, then you take the matter to the government. That is when the government comes in. The government will not police for you, right? So when you register your rights, what you have to do, you have to police. Now, while you are policing, if you come across someone that is using your rights without your permission, what do? You need to enforce your rights. And this is where enforcement comes in. Now you've enforced your rights. What next do you do? Next thing is for you to monetize your rights. Whenever you enforce your rights and you are going through the either the arbitration, mediation, cease and desist letter, injunction, whatever, lawsuits, you get money from it one way or the other. So that is one way of you monetizing your rights. The other way is for you to license it, you sell it, you transfer it, you do so many things with it. So this is just like the IP life cycle. So from your idea, you create that idea, you register it, you police it, you enforce it, and then you monetize it. So that's basically the overview. These are types of rights. I know Kati mentioned the industrial property and copyright, so I'm not going to go into that. So IP registration, like I said, ideas will always come, be it a stupid one or a beautiful one. There can't be registration or protection of an idea without creating or expressing the idea. So the question is, why then do you have to register it? Now, unfortunately, the body responsible for registration in Nigeria, we adopt the first to file as opposed to first to use. And Kachi was saying something like that. Even if you are the first person to use it, the fact that you didn't register it first, the person that registers first has that upper hand over you. So it's best for you to actually register your rights as at when due. Although you would like to, maybe you want to test the market to see, okay, is this right worth it? Just like Ashi said, if you have a copyrighted work, should you just register it immediately? No. Yes, depending on the value of that work. If you're able to value it and say, this work has value, then fine, you can deposit your work. If it doesn't have value, you can decide not to, right? So have you heard of the term poor man's patent or poor man's trademark? So poor man's trademark is just like your trademark that is not registered. You don't have any certificate to prove that you've registered it. So we kind of call it poor man's patent and poor man's trademark. Then poor man's patent is the one that you send your the details of your invention, everything about it, you send it to yourself like an email instead of you to go ahead to file a patent application for it. That's just something around it. Then duration of protection, you already know that one in the previous class. So let's go to intellectual property infringement. So IP infringement refers to unauthorized use, production, license, sale, etc. of the creation of someone's mind. So from this image here, you have someone trying to probably express their rights by typing it out. Then there's somebody that is always there to check whatever you are doing and trying to steal your rights. And this last image, you're seeing, this is where you catch that person rendered. So you want to steal my right back, and now you want to infringe, and I've caught you. What next do you do? So difference between infringement and passing off, probably we'll deal with that in the question. So now you've caught that person that is trying to infringe on your rights. What do you do? What you do, the person that infringed or trying to infringe, what you do now is for you to enforce this right. So IP enforcement refers to the act of putting measures in place against the usage of your intellectual property rights without your permission. So why do you need to enforce? You have this idea here. Idea is buzzing in your head, but there's always somebody. As long as that idea has that tendency to make money, trust me, somebody somewhere will want to steal it without your permission. So this person is trying to steal it, and you are able to see that person that, oh, you want to take my idea away, blah, 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 but you're able to catch that person here. Now you want to enforce your rights. How do you now enforce your rights? Now, consult an intellectual consultant to be sure your right was actually infringed. Now, we've seen so many cases whereby, in fact, you are saying somebody has infringed on your right, but the truth is you don't even have the right in the first place. let's say, for example, you did a copy and paste of somebody else's copyrighted work, and now you are saying somebody has infringed your rights. Tell me what rights you have, because that copyrighted work you're talking about is not original to you. Even if it is fixed, it's not original. And you know that our copyright, for your work to enjoy copyright protection, it has to be original and fixed. So in most cases, you realize that these people don't even have an IP right in the first place. And then you are saying somebody has infringed on your right. So the first thing is consult an IP consultant or an IP lawyer to be sure your right was actually infringed. Then get a lawyer to draft a cease and desist letter on your behalf, then send to the infringer. That's if truly your right has been infringed. If the infringer doesn't change ways, then you can also report the undo on social media platform, just like Group 2 presented, the DMCA, the takedown order, and so on and so forth. Now, if you can also afford lawsuits, then you can go the lawsuit route. If otherwise, bargain with infringer and probably settle out of court. So those are that's just my presentation. Basically, they've done everything. So just to add that, I think we'll take questions now. Thank you.
Thank you so much. Mentees, do not forget the chat box. Go there and, of course, say some good words to our mentor. Remember, I told you before that when she comes through, you would always hear create it, protect it, police it, enforce it, and monetize it. So thank you so much, ma'am. Thank you. I love the fact that wow, it's like the IP space, everybody knows everybody. This is nice. It is really nice. Thank you so much. Okay, so over to our mentees. Let's get questions. We need live questions now. Please, as snappy as possible. Let's all get really involved. Let's get really involved. Come on. Let's get questions coming out. Are there concerns you have? I know someone asked before. Yeah, someone had asked earlier, to our mentors, someone asked earlier, I think Mr. Max, you were speaking then, that what happens for, with regards to ADR routes, where it has to do with patents, but it is on licensing, and licenses are usually contracts. So what happens where the disputes being brought to probably arbitration is based on, is that an issue on patent rather being brought to arbitration is based on a license given on a patent, probably to a third party. And again, is it possible to give a license to a third party by someone who has gotten a patent license from the government? So over to our mentors. Can we speak on that briefly, please? Mr. Max, probably I'll start with you because you were speaking when that question came through. Hello, Mr. Max. Okay. Can I have Mrs. Onyekachi take?
All right, that's fine.
Okay.
I don't know if Shukrat is still there. I think I'm seeing a slide. If you could turn that off. I was just going through the chat box to see if I can see the question. Do you mind repeating that question?
Okay. Someone asked earlier. The question was, what happens? We're talking about the rights of with the Constitution 251, talking about the rights of the Federal High Court, and then taking matters on IP to the arbitration to arbitration or thereabout, or ADR. And someone asked if, okay, does this mean patent-related disputes are totally exempted from arbitration? What of cases of breach of patent licensing agreements? And that's likely more under contract. So what of situations like that where what was breached was basically for patent licensing agreements?
All right, thank you. I think Max already answered the question on that. So, but when it has to do with the contracts, I said it before, pacta sunt servanda. That simply means, sorry, I'm not putting on the camera because there's no light, and I think the shade, once I lift it, it might be affecting your sight. So that's why I turned it off. All right. Based on pacta sunt servanda, what it simply means is parties are bound by the terms of their contracts. So at the point of me giving a license to someone to use my patent, I'm not giving rights or maybe exposing or saying, go and create my patent or work my patent or something like that. Although that can also come in. But in the instance where I'm giving you right, I've made this, I've created a patent, and then maybe it's on a product, so I give you right to export it and then to sell to another jurisdiction, maybe other than Nigeria, for instance. And then you take this right to Ghana to go and sell in Ghana. And then you get to Ghana and find some other person in Ghana who lives in maybe in Cameroon and wants to move those goods from Ghana to Cameroon. Now, can I use ADR to make sure the person does not go to license to another person? Sure. If the parties have agreed to be bound by ADR, that their dispute is going to be settled based on the terms of, based on ADR, even if we say you have an arbitration clause in your contracts, so you must go back and first resolve using this arbitration. It is not until it fails before you can seek alternatives, say in the court. That's on the one part. And then please note that depending on the terms of the license, there are some license agreement that will say, I'm licensing to you, but you can't sub-license to a third party. And then if there's a caveat like that, if there's a nuance or if there's a term of the contract that specifically stated this, it means I, as the licensee, I cannot sub-license to somebody else. And once I've done that, I've breached the contract. And if the contract says, because you breached this contract by, licensing to someone else, then what's going to happen is going to lead to termination of the contract and all rights will revert back to me. So depending on what the parties have agreed, then that is going to take effect. So if I've said that if you give my rights to someone else without my consent, then I'm going to foreclose on this contract between us. I'm going to terminate. Then I have a right to actually sue in court and say, I want to terminate. Or during the ADR, that version or that part of the term of the contract is going to be interpreted to show the same. And some will now put a further clause to now say, when you do that, you are going to pay me so amount of money. Whatever we have agreed, by reason of our agreement, we are both bound by it. So I think I'm going to stop there, but if it hasn't answered your question, I will appreciate you repeat it because I've been looking at the chat box to see the question myself. So really appreciate how far you want me to go in answering the question. Thank you.
Okay, thank you. I'm trying to check for who sent that question in so that he could probably give a live ask of his question. I think that came from, that was Oluwasegun. Is Shagun still with us, please?
Yes, I'm here.
Okay, so Oyekachi was giving answer to your question. Was that
Yes, ma'am.
okay for you?
Thank you. It was okay as to the aspect of the enforcement. Now, I was asking that if I could put it in another context. One of the things Mr. Marks mentioned was that there was currently an argument against the use of ADR when it came to patent, which was actually what brought about the question. That is the fact that patent is more of a federal government policy thing. It blocks it from being like enforced or things like that by ADR. And that was why I asked that question also, that also what of cases where the dispute is not really from the place of whether the patent was issued or not. What about licensing? And that, I think that was what she explained. So I think my follow-up question to that would be, so have there been any occurrences where such ADR may have been like overturned, like the awards overturned because of that area of patents being a thing of governmental policy, like practically speaking?
Okay, Matt, so back to you now.
Okay, yeah. Thanks for that.
Okay, Mr. Max is
Oluwasegun. I hope you can hear me.
Yes, sir. Yes, sir. We can hear you.
Yes, sir.
Okay, yeah, thanks for that question, Oluwasegun. Indeed, it's a very touchy and controversial area. Like I told you, with IP, we don't have any direct decisions of the court yet on the arbitrability of IP disputes, but we draw the analogy on this issue from tax. Tax has been one of the hot areas where this argument of, first of all, starting from Section 251 of the Constitution and saying that it's a matter within the exclusive jurisdiction of the Federal High Court, and therefore you cannot use arbitration to resolve IP-related disputes. So it is from the decisions of the courts in tax that we can, draw an analogy as to what the decision would be when the question of IP comes up. So based on that decision, which has also made a clear distinction, saying where it's a contractual issue, the contractual issues can be resolved through arbitration, but the tax dispute cannot be resolved through arbitration. So I would say also just, in line with the example that Onyekachi has given, just that with the example Onyekachi has given, usually what a mischievous respondent will do is that when you file a claim against him in that context, saying, look, I only licensed you to use my IP in Ghana, you're trying to now use it in Cameroon. What the mischievous respondent will do is to now challenge the validity of your IP right, and therefore now bring into question before the arbitral tribunal the validity or otherwise of the IP right. So that will now, in a sense, hamstring the IP tribe, the arbitration tribunal, because the arbitration tribunal at that point now knows that, look, we cannot give a determination on the question of whether the IP right itself was valid or not, because before you determine whether there's the right of licensing, you have to determine whether there even exists a valid IP right, because when the claimant is challenging the right, or challenging the misuse of the license granted to the respondent, what he's saying essentially is that I have a valid IP right and I licensed it to you. So it means that underlying that dispute, first of all, is the validity of that IP right. But if the respondent, or if the dispute is clear that it's maybe about money, how much you're supposed to pay me for the licensing and all of that, then it's clearly a matter that arbitration can resolve. But the moment it touches on, the issue of whether it is valid or not, then it becomes problematic. So I would say that, so far as in my own opinion, so far as Nigerian law is concerned, the moment the dispute touches on the validity otherwise of the IP right, in this case, trademarks, industrial design, and patents, then arbitration, it might be difficult to use arbitration to resolve, except both parties agree willingly. So I would also give an example that in some countries, like in Germany, the decision there is quite different. So what they say is that the arbitration tribunal can give a decision in personam. In personam means that as between the two parties before the arbitrator, you can decide whether that patent is valid or not. But that decision of validity or otherwise of the patent does not affect third parties. So any other person who is not a party to that dispute will not be affected by that decision. So I don't know if you get that distinction now, that some decisions will now say that the issue of validity or otherwise, the arbitration tribunal can only give a specific decision that binds both parties. So if the tribunal says this patent is not valid, it is only binding on the two parties to that dispute, but not binding on third parties. So it means that the claimant can still enforce his patent right against third parties, but not against that respondent. So that's also another way to slice it. But I would say that in Nigeria, it would be risky to go that route. That Nigeria, the moment validity of the right is called into question, my advice to the arbitration tribunal would be to hands off and let the courts decide on that. Thank you.
Sorry if I may add to that also. When we talk about validation of patent rights especially, and why it looks like AGI is not so perfect for it. When it comes to patent, you begin to think about a patent, the claims comprising of this, comprising of that. So they are totally detailed. And sometimes the chemical composition or whatever was brought together to make that patent might not necessarily be something you say maybe one expert, like if it's a case of mediation, even if it's a case of arbitration, you can have a sole arbitrator to come and sit and then begin to discuss. Sometimes it might involve considering so many literatures to want to say, oh, is this patent valid in the first instance? Are there literatures in the public domain that invalidates this patent? For invalidation to come up, it means a patent was granted by the registry. However, for some reason that could have come up during pre-opposition case, such as you could have opposed prior to the grant of the patent, and for some reason you missed out that period. Maybe you didn't see the publication, you were not aware of this new registration or what have you. And then somebody wants to take what is in the public domain to write on it as a patent and then begin to license all about. And then you get a hint of it, you decide to go to court to invalidate that patent. It's not always something you bring into the bedroom to want to decide through ADR. Remember, ADR is more or less, how do I put it? It's just between you, the parties, and then maybe the arbitrator. But when we go to court, in fact, the more we're in court, the more people bring evidence to oppose that patent. I recall a case of turmeric. In India, turmeric is said to be very active as a healing product. Like if you're cooking in the kitchen and an accident happens with a knife, you cut your finger, just put turmeric. And turmeric has been there for God knows how many years, over hundreds and hundreds of years in India, that everyone in India can say, cut your finger, put turmeric on it. And then somebody moves to America a few years ago to want to go and register a patent in America. And then he says a method of using turmeric as for healing process, something like that. And then the Indians got the wing of that and then immediately opposed the mark from being granted. Now imagine they succeeded in granting that patent because they were about granting it actually at the time the Indians came up to fight that grant. Imagine they had concluded and they had granted that mark because there was no literature. Now, during invalidation, it puts that patent in the open. It makes it more announced. In fact, you see somebody maybe from far away who has no business with a proceeding. Such a person has a right to bring more literature to the courts to say, I may not be a party to this suit. It's not like a normal civil suit where they say it's only the parties to the suits that have a case to answer. When it concerns patent, it is a right that when you are granted is for 20 years. You can do and undo. I recall when Marx was talking, he said it's a monopoly. In as much as there's a school of thought saying it's not exactly a monopoly. That's a discussion for another day. But imagine it is a monopoly of rights. It means because I came up with turmeric, you can't even use it to cook in your kitchen anyhow without paying me a license. You can't even use it in your kitchen to heal your wound again, because you need to pay me a license. That's the implication of it. So everybody from every quarter, from every angle, had to bring out what they knew was in the public domain. To say this thing is in the public domain, my forefathers gave me this 100 years ago, and my great-great-great-grandmothers kept passing it down to my generation. That's evidence number one. Another person comes from maybe far away, maybe somewhere in Africa to say, I left Asia 50 years ago with my generation, and then since we have been living in Africa, the only thing we came down here with is turmeric, and we know it to be healing wounds. Are you seeing that? So these are all the information the court now puts together to say, there's amazing evidence to say turmeric, you can't take it alone. You can't have a monopoly over it because it's in the public domain. And what IP does is this. It does not allow anyone take what is already available to the public. You bring it in and say it's just for me. Because IP makes those rights. Remember I said something about IPs are private rights. Initially, I first said IP is generally classified. The right itself can either be communal rights or private rights. So patent, trademarks, and what can be private rights. But when you talk about geographic indication, plant variety, genetic resources. They are more communal rights. Now, you want to take something that is meant for the public because it's already in the public domain. Nobody owns it. You now want to make it your own so that nobody can use it. Because once it is granted, it means nobody can have free use of that thing. So everybody comes out, everybody brings out every documents they have. It doesn't necessarily have to be that that thing has been formally created, packaged, and sold in the market officially. It can still be that that thing is sold raw, or that people have access to it in their farmland. All evidence you have goes to court. But imagine you're using arbitration. Maybe the only evidence A has is just a piece of paper, and that piece of paper, you can't necessarily tell how far that paper has been in the public domain. You can't necessarily begin to define the history surrounding that paper. It is kind of closed. Do you understand what I'm trying to say? But the court system is an open system that is accessible by anyone, everyone. Whether you're in the US or you're in Canada, just send in what you have, even though the court is here in Nigeria. So patent invalidation through the court system gives you that opportunity. But when you use arbitration, it doesn't necessarily. I think it's one of the reasoning behind why the processes of a patent or the composition thereof is not something you use arbitration for. But the aspect of the contracting, maybe we are both agreed, I've done my own patent, I've done whatever. So now let's talk about the contract. Then you can use arbitration on that part because pacta sunt servanda, like I said before, you are bound by your agreement. But on the other parts, when you have the composition thereof, all the things they mix together before this patent was created, and then somebody is saying there's no inventiveness or there's no novelty, those aspects goes to the court. I think this is a better way to just differentiate the two. Thank you.
Thank you so much, ma'am. Thank you. Thank you. Wow. 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 Yes, yes, of course. I love how they stepped out for it. Thank you sincerely. This has been really amazing. Thank you so much to the amazing Mr. Max, to the beautiful Mrs. Kachi, and then the goddess herself. Thank you so much to Mrs. Shukurat. Thank you. This is the much we can take on today's session. It's been really phenomenal, really, really phenomenal. But I think before we round off, quickly, can we take our picture time? I'm sorry, I think we should have done this earlier before now. So quickly, can we just take our picture time as quickly as possible? As many of us who can have light, please just, if you can, let's quickly turn on our cameras to just take our pictures. Some of us is pretty dark, but let's just get some pictures out. Okay, we could probably smile. It's IP, so IP brings joy when you're protecting your creations and monetizing it. So we could actually smile. Thank you, thank you. Okay, so once the photo is taken, we'll be told. So we have these amazing faces. Okay, thank you, sir. Thank you. We have these amazing faces here today, and you've been all quiet. Most of you have been quiet. Why? So here at Jiipcc, do not forget, Mrs. Shukra said it earlier, to group one, please, you need to know that this is a training process. I was once a mentee of this same training. I went through these classes you went through. I met our mentors through this same process. And trust me, it is amazing. There's so much knowledge here. There's so much bond you get amongst yourselves. You must not be the presenter to get ready for a presentation. Do not forget, these things are recorded and then put on YouTube. You do not know who is going to watch this. So please take this process very seriously. Our mentors are seasoned professionals in this field. The truth is, when they hear you talk sometimes, they can be marveled. Who knows, they could call you after sessions or try to reach out to you after sessions to see how to make a network with you. I always say this, I got a book from one of our mentors, an expensive book on data protection, because of my involvement during a session. I was not meant to present that day, but there was no presenter for my group, and I handled the presentation. I got the book from Lagos. So listen, we need to see how to make ourselves worth it. We thank God for Jiipcc giving us this kind of a platform where we can learn, grow. Getting knowledge like this is pretty expensive, but Jiipcc brings it to us at nothing. So I want to really advise us, please, let's take this really seriously. Our mentors are doing a great job. They're doing a fantastic job at giving us great quintessential knowledge, which means we need to bring the same energy. Group 1 members, we're going to be reaching out to you in the group. Trust me, it might not be the best week right now for you because Group 1 we needed that same fire from you. But Group 2, thank you so much for stepping up to the game. Thank you for a fantastic week. One more time, thank you to our amazing mentors. Thank you to Mr. Max. Thank you to Mrs. Rikachi, rather. Thank you to Mrs. Amosa. Thank you to Mr. Dennis for being with us throughout the call today. Thank you so much. And of course, yes, Saint Ame, thank you for a wonderful, fantastic presentation. That was, I think, one of my top presentations so far in the Jiipcc program. And to Oluwasegun, thank you for being so active throughout today's session. A big thank you to Jiipcc for this opportunity. Until our next class, my name is Goslav Kamalani, and that's the best we can take on today's session. See you next time. Do not forget, advise someone to register for next quarter. Have a very fantastic weekend. Bye-bye.